Digital technology has brought about tremendous changes in the way legal practices around the world have been conducted in the last 2 decades. According to Professor Frederick, the courtroom is a place of adjudication, but it was also an information hub. Outside information is assembled, assorted, and brought into the courtroom for presentation that results with collateral consequences, which is then transmitted throughout the legal system. The courtroom is thus the center of a complex system of information exchange and management. Good evening, ladies and gentlemen. Law Essentials and Legal File welcomes you to the webinar on virtual trials in the new decade, substitution or replacement. I am Mohammad Farhansi, founder at Law Essentials India and publisher at Law Essentials Journal. Now, let me introduce you the speaker for today's session, Advocate Vivek Narayan Sharma, sir. Thank you so much for joining here with us, sir. Sir is a socio-political constitution expert and renowned advocate practicing at the Supreme Court of India. He is the ex-joint secretary of Supreme Court Advocates on Record Association and also the president of Society for Criminal Justice. He is also the national advisor, consultant, and convener for eminent socio-political outfits and law journals in India. He is an academic council member at KCC Institute of Legal and Higher Education, Greater Noida, NCR, Delhi, apart from various other qualifications he possesses. We are privileged to have you as a speaker for today's session, sir. We are extremely honored for this opportunity.
Thank you, Faraji. It's a pleasure to be here. Thank you. So you will let me know when I have to start. Do I need to start now?
Yes, sir.
Okay, pleasure. Very good evening to all of you. It's a pleasure to connect through the medium of Legal Essentials and Legal File. And my best wishes to all the team of Legal Essentials and Legal File, including Mr. Mohammad Faraji and Priya. So today we are going to talk about a very, very important topic, which is going to change the basic scenario in India in the coming days with regard to not only litigation, but also the mediation and arbitration. So there are various adjudications, kinds of adjudication. Adjudication is by way of agreement, adjudication is by way of arbitration, and litigation means most commonly known as means the court adjudication process. So now while the government is already in the making of the law on mediation, a totally new law which is going to come, so giving a profiling with regard to the litigation prior to the people entering into litigation, there would be a requirement to go into mediation as per that law, as I understand. Means once it is passed, only then we can really have the real work, the horse coming out. So what happens? There are various sources of adjudication, as I already told you, which is agreement, arbitration, litigation, mediation. So not all adjudication require trials. So today's topic, as we are seeing, virtual trial, substitution or replacement. And on the periphery, if you look at this, means substitution and replacement both look at the synonymous words, but they have a little bit difference. Substitution means vikalp, and replacement means badlav, pratisthan, so alternative equivalent. So whether this, after the coming of COVID into the system of the entire need of the entire world, lot of things have started taking place through the video conferencing mode. We are seeing that Supreme Court is functioning for last so many months through video conferencing mode only. And similarly, so many other courts are functioning. But at the same time, trials are not taking place. If you are aware about it, various high courts have issued the directions for their local courts that the trials means evidence will not be taken. And during the early period, evidence was not being taken. Not being taken. Now, some of the high courts have started directing their trial courts to start taking evidences also. So now we are talking about the virtual trial today, substitution or replacement. Whether ये एक विकल्प है, means it can be just in addition to the physical trial which takes place. Can there be a possibility of virtual trials taking place in future, or it can be totally replaced, that there is no requirement of a physical trial and all trials can be taken place through the virtual mode. So today's topic is this, and while I may say that in maybe 100 years from now, there is a possibility that all the trials may take place through virtual modes and not through any physical mode. But I don't see anything coming so soon that it would be replaced, that physical trials would be replaced through the virtual trials. Because what happens, there are various nitty gritties of the trial. And but before talking about those nitty gritties, I must aware, make all of you aware that trials are not essentially the proceedings which take place in Supreme Court, in High Court, and it is only the trial court in the lower courts where the trials usually take place, where the original jurisdiction happen, where the trial, where which is the primary stage of any litigation. So if a trial means, I must make you understand also before we start talking about the trial proceedings, the trial, if you look at that, trials are provided under the criminal matters and civil matters in the nature of suits and all, but not in the jurisdiction, and not those summary proceedings. And in all the tribunals and all means, maybe in arbitration also, usually trial does not take place. What is the essence of trial? Essence of trial is that the witnesses and documents, witnesses have to be examined and the documents have to be proved. In writ jurisdiction, if you look at that, or in SLP, means these are the essentially the appellate jurisdictions. So in writ, which are the original jurisdiction, the trial usually do not take place because no witness is usually called in the court to give evidence and to depose. And similarly, the documents which are filed are not exhibited. So those documents can be the photocopies of their respective originals, and they can still be relied upon. So that's a form of proof which is required in writ petitions. But there are so many other proceedings, like in tribunal, similar procedure is adopted. But when we talk about the original suits or original jurisdiction, that is the primary stage of any litigation, say for recovery of money, say for recovery of property, or say for the dispute between two parties for any amount, for any reason. So if that kind of litigation is involved, then the primary stage would be that the party will have to, whoever is claiming against the other party, will have to prove. And what is the basis of proof? In the civil matters, it is the preponderance of probabilities. So while you may have direct proof, suppose you have given some goods to X party and the X party had issued you the confirmation of receiving the goods, and the goods, the money is still due. So in a common parlance, in a simple scenario, because you have the evidence that the X party has given you this confirmation by after receiving, and then you had raised the invoice, so therefore you can prove it. But at the same time, it is not so simple. You will have to exhibit those documents before the trial court, so that after you show the document that these are there in original. So there are various types of evidence: direct, indirect, primary, secondary, means evidence act. You can all go through. So you will have to prove. So when we talk about the civil matters, certainly means with regard to this exhibits, of course the counsel will have to go before the court to prove, to show the exhibits. How would the original be verified? The original will have to be placed before the eyes of the judge, so that the judge could look at the original and can verify, okay, these are the original. Because what I show on paper, it may be a colored copy of the original, so it cannot be verified. So essentially, if you look at that, if you have to mark the exhibits in the trial court, then for that purpose there has to be a physical appearance. So we are talked about documentary evidence in a civil matter, and but if we talk about the witnesses, examination of witnesses and cross examination of witnesses, then what happens? So means there has been a precedent in Salem Bar as Salem Advocates Association matter in 2005. Justice Sabharwal, this is a three-judge matter, which had allowed taking place of evidences, witnesses, statement through by way of video conferencing. So that's the precedent we have. Similarly, in criminal matter, which I will talk about later, there is another matter in which, under Section 273, the same thing was allowed by the Supreme Court. This was Justice S. N. Variava back in 2002 in the Dr. Praful B. Desai matter. So I will read some of the relevant para of that judgment as well for your information and for your benefit. So in the Salem Bar Advocate Bar Association, Tamil Nadu versus Union of India, that is 2005 matter, it was one of the first cases that broadly interpreted the provisions of CPC and allowed for the use of electronic media during the evidence stage. Order 18 of CPC, which dealt with the examination of witnesses, states that the court or the commissioner shall record evidence either in writing or mechanically. So the Supreme Court, while interpreting this provision, held that the word mechanically indicates that evidence can be recorded with the help of electronic media, including audio or audio-visual apparatus. So that's what is the landmark judgment in this area where the recording of evidence was allowed under Order 18 CPC by way of electronic media, means video conferencing or any other mode that you can think about. So that being the case in the civil matters, now as I told you, there are various documents to be proved. So with regard to proving those documents, you will have to show the originals before the court or maybe file the originals before the court and mark the exhibit. Exhibit marking is still a thing which takes place by the hand of the advocates in the courts. So for that, the presence is required, and rest of the matter, when we talk about trial takes place in several stages. Trial starts means I must inform you when the trial starts and when the trial comes to an end. You must all be aware about it or not, means I'm not sure. But the moment a witness has been filed, this evidence has been filed of a person who is involved in the case. Suppose a plaintiff is there whose evidence has been filed in the case. So the moment it has been filed and tendered, filing of evidence, suppose the evidence is filed on 1st January 2021, but the tender did not take place for 1 year. The tender took place on 1st January 2022. Then the trial will commence only on the date of the tendering of evidence, not on the date of filing of the evidence. And this is very important question. Why so? Because so many times while the matter is going on, the parties feel that there is a requirement of change the pleading, requirement to change the pleadings before the court. So the CPC do not allow, once the trial starts, there is no provision that you can change the pleadings now. Prior to 2000, the situation was so that you could have changed the proceeding at any given time for various reasons shown. But post 2002 amendment, the position had been, means once the trial has commenced, you cannot change the pleading. Means of course, means there have been certain exceptions to this rule as well by way of Supreme Court. But at the same time, this is the primary rule that you cannot change the pleading. So the commencement date of commencement of trial is very important. So whatever amendment in the pleading, in the suit, in the WS or in the application you want to bring, you have to bring those changes only prior to the commencement of trial, and trial commences when the evidence is tendered. Evidence of the plaintiff is tendered, not of defendant. Defendant's evidence will come later on, but then trial has already commenced at the point when the plaintiff has filed the evidence and tendered the evidence. Means tendering is called when the plaintiff is present in the court, and in his presence the counsel has marked exhibit A, B, C, or if there are Xerox copies of the document, then they are marked as mark A, B, C, or mark 1, 2, 3, whatever denomination you may choose. So this is how the evidence is tendered. So once this thing happen, and once all the witnesses have been examined, and nothing remains, now the matter has been put for final argument. So once all the evidences have been examined, prior to that, all the relevant documents have been filed and tendered through the evidence, then the trial has been completed now. It's complete now. So now only the final arguments remain. So final arguments in the matter are different from the trial. Filing of the matter is different from the trial. So there are three stages of this matter. This is how you bring out. There is a pre-trial stage. There is a post-trial stage. In the pre-trial stage, and then there is a trial stage, third stage. So pre-trial stage, you file the cases. Pleadings are completed. Issues are framed. If there is some discoveries to be made, if there is some inventories to be discovered, or some documents to be recovered or sought from the other party, all those stages can be found in pre-trial stage. Second is trial stage, where the tendering of evidence and all the witnesses' statement, cross-examinations take place. Then post that, there is a post-trial stage, which is the argument stage. On the basis of all the documents, pleadings, everything that now you have summed up what your case is and you have brought out of it, and then you can rely on the judgments or various precedents of courts above or the similar courts which have been hearing the matters. So in the civil matters, this has been the way to conduct trial. Now, um, trial usually happen in the trial courts. Means trial court means the sessions courts, ADJ, district judge, or a civil judge in conventional forms. But then there is a original jurisdiction provided in various states to the High Court, just like in Delhi. On the contrary, in Chandigarh, in Punjab and Haryana High Court, there is no original jurisdiction provided to Punjab and Haryana High Court. So in there, all the matter at the primary stage have to be filed before the trial court, before the court of ADJ, civil judge, or district judge, so on and so forth. But in Delhi, if there is a pecuniary jurisdiction which is more than 2 crore rupees, so if the matter, the worth, that is the claim which is being made is worth more than 2 crore, then the case has to be filed before the Delhi High Court in the original. So now all this pre-stage, pre-trial, trial, and post-trial stages would be before the High Court only. So High Court may appoint a commission to examine the witnesses, to complete the trial proceedings. So it may be a registrar of the court, or it may be a separate commission which may be appointed by the High Court. So usually it is the single judge which hears the trial matters in the High Court. So this is how the trial takes place in conventional matters. And post that, then when you go in appeal, then first appeal can be a trial. If there are some disputed questions of fact which are being raised, then and you have to prove the certain facts before the court, then in that case you can plead them. You can plead them very well, and you can reprove them with the permission of the court, because first appeal in the civil matters is a court of fact and law both. Second appeal is only on question of law, and then subsequent appeal like special leave to appeal or civil appeal before the Supreme Court, they would be all based on the question of law. So this is the slight format of the trial that takes place before the court. And we will now talk about something about the criminal trial. So criminal trial, as I told you, in the case of Salem Bar Association matter, Tamil Nadu, back in 2005, Supreme Court passed a judgment by way of which it had allowed uh, virtual recording of the evidence under Order 18 of CPC. So similar is the fact here. So there was an ambiguity about the use of audio-visual equipment during a criminal trial, which was settled by the Supreme Court in the case of a state of Maharashtra versus Dr. Praful B. Desai, decided in 2003 by Honorable Mr. Justice S.N. Variava. It was a division bench of Supreme Court. So while the issue was decided, The court, while delving into the issue of presence of accused in the court as mandated under Section 273 of the CRPC, held that the term presence does not mean only actual physical presence. The court thereby allowed the use of video conferencing for recording evidence in a criminal trial when the accused or the witness cannot conveniently be examined in the court. So you will have to go through this judgment, I am sure, just like Salem Bar Association judgment, and similarly this. You must go through. I am just going to read one paragraph from this judgment, para 10, which reads, this court was taken through various sections of Criminal Procedure Code. Emphasis was laid on Section 273 Criminal Procedure Code. It was submitted that Section 273 Criminal Procedure Code does not provide for the taking of evidence by video conferencing. Emphasis was laid on the word except as otherwise provided in Section 273, and it was submitted that unless there is an express provision to the contrary, the procedure laid down in Section 273 has to be followed as it is mandatory. It was submitted that Section 273 mandates that evidence shall be taken in the presence of the accused. It is submitted that the only exceptions which come within the ambit of the word except as otherwise provided are sections 284 to section 290, those dealing with the issue of commissions. Section 295, affidavit in proof of conduct of public servant, and section 296, evidence of formal character of affidavit. It is submitted that term presence in section 273 must be interpreted to mean physical presence in flesh and blood in open court. It was submitted that the only instance in which evidence may be taken in the absence of accused under the Criminal Procedure Code are section 317, provision for inquiries and trial being held in the absence of accused in certain cases, and section 299, record of evidence in the absence of the accused. So it was submitted that as section 273 is mandatory, the section is required to be interpreted strictly. It was submitted that section 273 must be given its contemporary meaning. The contemporaneous exposition is best and the strongest in law. It was submitted that video conferencing was not known and did not exist when the Civil Procedure Code was amended. So it was submitted that presence on a screen and recording of evidence by video conferencing was not contemplated by the Parliament at the time of drafting or amending the Criminal Procedure Code. It was submitted that when the legislature intended to permit video conferencing, it has expressly provided for it, as is evident from the ordinance passed by the state of Andhra Pradesh in December 2000 permitting the use of video conferencing. So all these were submitted. It was also submitted that section 273 is analogous to confrontation clause set out in Sixth Amendment to the US Constitution. It is submitted that court in USA have held that video conferencing does not satisfy the requirements of confrontation clause. So all this was submitted to give a meaning to section 273 that electronic evidence is not included in section 273. And yet, the Honorable Supreme Court decided that the words contained within the ambit of Section 273 to the extent will include, except as otherwise provided, will include that the evidence can be taken through video conferencing in the criminal matters as well. So this is another landmark judgment with regard to the criminal matters here. So now, as I have given you some outline with regard to civil matters, how the trial takes place, and with regard to criminal matters, how we can introduce video conferencing. So now various stages are there. As I told you in the beginning that there are some documents which are required to be proved in the matter. Then in that case, the presence of the counsels and the party may require, and the court is required to look at the documents personally to see whether the documents appear to be true or not. If the documents this is customary that all the time documents are not filed in original. So court looks at the original document. At times, parties may need the document for XYZ reason. So then, in that case, at times it so happens that the parties restrain themselves from filing the original document before the court. So in such a scenario, what happens? The court looks at the original document, looks at the photocopy, and then allows it to be marked as exhibited. If the originals are not shown, then in that case, it is marked as mark. So to my satisfaction, it is very important for you to go through those the provisions of Evidence Act with regard to the direct evidence, primary evidence, indirect evidence, secondary evidence, and then various forms of evidence. It would be very, very important because the time would be short here, and then I would not be covering those areas today. So we would be talking more about the presence of virtual trials and how it can impact the future that we look at. So today, during this pandemic period, most of the cases have been heard through video conferencing, and in some of the matters, uh, some some sort of evidence have also been filed, but evidence had not taken place, especially in Delhi. Means it is still not being done. Now the parties are allowed to appear before the court and then tender evidences, and they may do so. So various courts, all the tribunals have passed certain rules with regard to conduct of video conferencing matters through video conferencing. And similarly, means when you have to do that, then you must know that it is not so simple. When you have to tender a matter, you have to file a matter through e-filing, there has to be a process. The document has to be received. There has to be the server which is robust enough, fast enough that it is able to take a filing of so many different matters at a time. And at the same time, then the document and case management has to be there. Means once the e-filing is done, all these documents have to go somewhere so that there could be easy distribution of those filings to the respective courts. Then another is then electronic evidence management. So prior to any evidence start taking place through virtual conferencing, we need to have in place electronic evidence management as well. So today we are not having all of these things. Today we have some process. The courts have e-filings, but it is still not so very much robust. They are still looking for, once the filing have been done through e-filing, they require the counsels to file physical copies as well. So e-filing will not be true e-filing till the time we require that filing of physical copies in the court. So there is no the proper justice to the system that you have to file either through e-filing as well, and then physical filing. Ultimately, there is a lot of wastage of papers in the process. So if we need to omit, prior to pandemic situation, e-filing was required to stop the wastage of paper. Paper is directly connected to the resources, our environmental resources, that is trees and plants, water. A lot of water takes place in making the paper. So there are various reasons. Post-pandemic, the reasons have changed. But those changes are only transitionary in nature. Once this pandemic situation comes down, then we come back to the situation which was prior to the pandemic days. So where we have to work on the resources, we have to look at the sustainable resources where life could be sustained in a way where we are not harming the environment too much. So if we look at the situation from that angle, it becomes very, very important that we should have all these robust systems in place where e-filing, document case management, and evidence management is in place. So today it is not there, but I'm not very hopeless about it. I think in the coming time, in coming 2 to 5 years time, many of us would see, in at least in those district courts of the metropolitan cities, that there would be these processes started. So then the fourth area is listing practices, how the matters have to be assigned, how flawlessly the matters could be listed, relisted, and dates could be marked, and all those things are there. So now, what are the problems which are arising? What are the big problems? Of course, we do not have those kind of infrastructure right now ready for all this e-filing, case management, document management, evidence management, and also listing, automatic listing of the matter. So that infrastructure is still missing. The second thing, which is very important from the perspective of the councils as well and judges as well, that the internet is still a scarce source in India. While we are sitting here in metropolitan, I am sitting in Delhi, you might be sitting in some of the metropolitan or maybe some of the remote area. I do not know what kind of remote connection you have, what kind of internet connection would you have, and what is the speed it is posing you. Whether you are able to understand what I am saying simultaneously as I say it, or it is taking time, the voice is taking time to reach you. So we do not know how things are going. Optical systems are in place in various places in India now, but still the speed is very lethargic here. So there isn't enough bandwidth infrastructure to really go about. High speed internet is very important requirement of this particular thing, and also the quality of internet. So till the time we see that India has all the corners this high speed internet and good quality internet, then this plan of virtual trial will not be successful, because ultimately what the virtual trial will do, virtual trial will do that the witnesses which are required to be examined in the court, witnesses which may need to come from remote area, from far area, from different distance area, different state, or maybe different country, to a place of trial, so that hardship can be mitigated, that expensive hardship can be mitigated for such a witness. But for that, in those remote areas, in difficult areas, in those terrains, the internet should be of high speed and good quality. If that is not there, even when the opportunity is granted to such a person to appear and give his witness and be cross-examined through virtual mode, then it will not be successful. It would rather waste more time of the court than to save it. And the time of court is also critical than an individual, and is rather more critical than an individual. Because the court has to hear so many matters in a day. A person, maybe one, he has to attend one matter of his own, but court has to attend maybe 100 people like him. So this balance has to be created. And this balance can only be created once we have this high internet and high speed internet and high quality internet available all around India. So in this regard, e-court missions mode project phase 2 has prescribed video conferencing facility in one court room in every district court complex. On test basis, it has to be there. So e-court mission mode project phase 2 has prescribed video conferencing facilities in one courtroom in every court complex. All lawyers may not have computers or smartphones. To facilitate digital access, it is necessary to set up of work areas in court premises. So it means providing those work areas in court premises, so that if we have to make this idea successful, then in that case you have to facilitate lawyers as well as the client, as well as their clients, so that they could come there, sit in those bar rooms or libraries instead of their own houses. Or maybe they don't have those arrangements, and at least at that place there is high speed and high quality internet. So if suppose a person belonging to Kerala, Ernakulam, has to give an evidence in Delhi, and he does not have that kind of setup, no high speed, he is not very much aware about the smartphones use, he is not aware about the computers and everything. He is a very means a farmer kind of person, and then he is not aware, he is not techno savvy. So what will he require? If the district court of the Ernakulam has that one room, one court setup, which is e-court setup, having high speed internet, so he can go there present himself there, and through the court's interference by way of use, and he can use that facility and give evidence sitting in Ernakulam in a matter which is being tried in Delhi. So how much money would it save for him? How much money would it save for the entire infrastructure? And at the same time, how much time would it save? Because what happens, he may give 10 reasons for not coming on 10 dates. So the trial would be delayed for those 10 days. I'm just giving a hypothetical example. So trial would be delayed for those 10 dates, and those 10 dates can spill over in 2 years or a year, 1 year or 3 years. So just because one witness has not been examined or cross-examined, and because this witness has taken time, and on different reasons he has sought excuse from appearing before the court, then what happens? There is a delay. And we know the delay is one of the biggest cause in India. So we can also expedite the trials in India. So if implemented rightly, if implemented very rightly with proper infrastructure, this thing, digital virtual platforms can really uh, help in providing speedier justice to not only the litigants, but also the name and fame to the entire nation. Another big factor which is very, very important is digital illiteracy, which I already talked about. Means in India, this digital illiteracy rate is about 3 times of the normal illiteracy rate. So means uh, whatever it is, there are more digitally illiterate people than the illiterate people. So it is very important that we start providing digital literacy to people all around. Then e-filing process is riddled with endless complications. I have my staff had great difficulty in so many occasions on so many occasions. Similarly, I have heard from others that there have been difficulties in e-filing, that the documents have been filed, they have been mailed, but they have not been received by the court. On the date of hearing, court comes to know. They say, all right, means when did you file? When did you mail it? Then they say, okay, we did not receive it. And yesterday only, in one of the matter, it was a final argument matter before the Supreme Court. The document had been filed, but the court had not received it. So therefore, they did not have the pleasure of looking at those list of dates which have been filed by us, and also the judgment which we had cited. But somehow we just screen share on that moment and save the day. But otherwise, there could have been date. Similarly, prior to that, day before yesterday, I was dealing a matter in a trial court. Some documents had been filed there, and the court had not received the mail again. So the court said, all right, you file it and I am giving you a date. So this is riddled with so many endless complications. So those complications, I can understand, these are also called the teething troubles. Digital platforms have been robustly used during this pandemic time to mitigate the loss of time. While we could have chosen not to do anything and sit idle, at least we are doing something in courts also. It is not functional fully, but at the same time, even if it is effective for 20 to 25%, so if 25% is better than zero. So this is an area which shall be overcome in the coming time, and I'm all hopeful with the right practices, with the right information, digital literacy, even to literate people, it is very important. Means when I said it is three times more than the illiteracy, that means even literate people are not digitally literate. So digital literacy and literacy are two different aspects. Today's time require that the people should have digital literacy. Then another area which comes to fore is hacking and cybersecurity, all the process which are going on. What is the security? WhatsApp has changed its policy very recently, 2 days back. So they may use those data that they have in the coming time. Post from 1st February or 8th February, they have marked a date. So what will happen because of that? So many sites we use, we have the video conferencing, we have the video, this various platforms through which the courts are conducting, or tribunals are conducting, and arbitrators are conducting their proceedings. So what is the security? So this is another area which is required to be looked into, which is very, very important. Of course, infrastructure is very important for all purposes. So security infrastructure to safeguard from cyber, to provide cyber security and safeguard from hacking is very, very important. So the another very important aspect is the maintaining of e-court record. So now everything is there. The paralegal staff is not well sufficient. As I told you, there had been some difficulties while I filed some matters in some papers. In some of the matters, they did not reach the court. Where did those papers go? Where did my mails go? So this shows that there had been some inefficiency on the part of paralegal staff of the courts. So which is not very well equipped. Teething trouble for us, teething trouble for them, but at the same time, they will have to pull their socks to provide the proper redressal. So they are not able to effectively handle documents or record evidence and make them readily accessible to the client or the court. So these are the things. Now, there are some probable good reasons why this virtual proceeding should take place. There are various kinds of crimes which take place. One of them is crime against children. Another one is crime against women. So in those matters, if the evidences take place through the video conferencing or the trial take place through virtual medium, then the witnesses are not as intimidating as they appear in person to the person who is the victim of the crime. The psyche of the victim of the crime is very difficult to understand in such times. But the underlying understanding is always this, that such psyche is so that they are in fear from the persons who have done some wrong to them. So in the digital form of evidence, witnesses taking place, digital form of trial taking place, such victims may not need to see those perpetrators, which will ultimately help them in their healing process. So in such cases, I think invariably this virtual trial should be adopted. While in all other matters, in commercial matter also it can be adopted, because in commercial matter parties are suitably equipped with their backgrounds of money and power and everything. So therefore they would have high infrastructure, internet infrastructure. They can deal with it. They can hire those counsels who have those who are technology friendly. So in these three areas, we need to think that the court should be the trial should take place in virtual mode only. In rest of the areas, there could be a hybrid. Whenever it is so needed, it can be in physical form. Whenever it's so needed, it can be in virtual form. And depending on the need of the client or the counsel, so courts may require to create a hybrid system in the future. And hybrid system to the extent that it allows the party to appear through virtual mode if it so wants, and the other party to appear in physical mode if it so wants. You mean to say that one party on a given date is appearing in virtual way, the other party is appearing in a physical way. The counsel may also appear in such hybrid manner. So our infrastructure should be so that if the party or the council want that I want to appear virtually, so I may be allowed to appear virtually. So how this may happen, it will take a little time, but it is something which can happen. It is not far away. What you need a screen. You need that robust system. Recently, I chaired the second Sustainable Environment and Energy Summit. So while the physical location was in Le Méridien, but at the same time there had been various guests, including the chief guest, various judges from different high courts, and some other guests of honors. They appeared. They the they attended the summit by virtual mode, and then half of the guests were also sitting there in physical mode, and some of the gathering was in physical mode, and most of the gathering was in virtual mode, and it all went very well. So what you need a screen, and those are kinds of attachment, technically feasible guys who can really make it true. Once the system starts, it will start with no looking back. So with all this means I will look forward to meet you guys again. If anything else Mr. Mohammed would want me to talk about, just let me know, please.
Surely, sir, thank you so much for that intriguing session. The audience have really been brainstormed by the words put forth by you. We have a few questions coming in from the audience. The first question is there any manual for instructions that can be shared for e-filing of cases?
Yeah, all courts have prescribed certain SOPs. So different courts, different tribunals have their own SOPs. So once you are going to file, so go on their respective websites, you will find some SOPs and then follow those instructions and then accordingly file.
Thank you so much, sir. The next question, does virtual trial apply in all situations? So there might arise this idea that it may not be feasible to do a mediation by a virtual trial because it requires the parties to be present in a single room to understand each other.
No. I don't agree with you on this. Not you, rather the person who had asked the question. Room means like right now we are in one single room. We are sharing our thoughts together and we are part of that one room. So it similarly means this can be a physical presence. Your presence can be physical. Your presence can be virtual. The only thing is you have to have this meeting of mind. You have to achieve that meeting of mind. You should be able to talk with each other. In flash would be, of course, it is advisable, but at the same time, it's not possible. One party is in London, another party is in Calcutta, mediator has been set up, the mediator is in Delhi, then it would be best in the interest of all the parties to have the virtual mediation. And this provision is being incorporated in the coming law.
Thank you so much, sir. The next question, how effective is virtual trial in today's scenario and will it address the speedy trial process?
It will address the speedy trial process, but effectiveness as on today is not very great. As I told you, there have been several teething troubles. At the same time, case management, electronic case management, and the evidence management is not in place. So till the time these two things are in place, e-filing has started, but it is not very emphatic and proper right now. So it has to be streamlined, and at the same time, the case management and the evidence management has to be provided as an infrastructure. And once it is done, then it can go in that right direction, if being effective and being expedient.
Thank you so much, sir. Let us take the last question for this evening. Please explain what are the difficulties faced by advocates in virtual courts?
Virtual courts are two different things. Means they are virtual trial and virtual hearings are two different connotations. Virtual hearings could be in all courts. Virtual trials could be only in trial court. And as I explained you, what is a trial? So when you are talking about, I think the question is with regard to the virtual courts. So the difficulties which are being faced by the councils are manifold at times, because so many times, like every court has different difficulty. In Supreme Court, the interface is so that all the counsels are are allowed to enter in one room. So in that room, there may be 200 counsels. With each counsel, their item numbers are written. Suppose for me, I am in item 2, and in item 2, there are eight entries, 8 persons in that room. Who would argue the matter? Who would be allowed to speak? So many times it happened, okay, one person is allowed to speak and rest of the 3 or 7 people are not allowed. If there is a respondent written, there may be multiple parties, there may be multiple counsels at time for those multiple parties. So it so happens that the presumption by those people who are dealing with this is this: okay, one counsel is going to argue all the matter, one for petitioner, one for respondent. So you need to just prompt him, write a message, and sometimes the message is written so late that the hearing is over. So these kind of teething trouble are still there in court. So for that means, of course, judicial staff which is working there has to understand how the court proceeding takes place. So they are still not aware of those court proceedings, because court masters are aware, but then court masters are not technical experts. So there is a gap. So that gap has to be bridged, and once this gap would be bridged, then certainly it would be a better situation for all the lawyers. And similarly, in different courts, there are different problems.
Thank you so much, sir. I think with this, we come to the end of the session. On behalf of the entire team of Law Essentials India and Legal File, I would like to express my heartfelt gratitude for taking your valuable time to conduct this session. It has been a great session, sir. Thank you so much.
Thank you and namaskar. All the very best. Take care.
Thank you so much, sir.